Okay, so our next speaker is a superhero for e-commerce sellers. When the bad guys at Amazon suspend your account, he swoops in to get you reinstated and saves the day. Please welcome CJ Rosenbaum from Amazon Sellers Lawyer.
Oh, the clicker? The superhero is great because, like, what every middle-aged man wants to hear from his awesome, young, beautiful China manager said that I reminded her of her father. Okay, so you all got a copy of our book on Amazon suspensions, and getting suspended sucks. It's the worst email you can get. It stresses you out. Your inventory's stuck, your money's stuck, and you're scrambling, you're not sleeping. But what you should also do is rest assured that even if Amazon turns down your plan of action, even if Amazon turns down your escalations, your Bezos escalation, your right to Kubicki, you can still get your account back. Okay? Amazon is not the last word when it comes to your account. Because Amazon makes you agree to all these provisions that are incredibly one-sided, and the one thing that you get, okay, the one part of that agreement that's actually good for you guys is that in exchange for giving up your right to go to court, you obtain the right to go to arbitration. Okay? So you get access to millions of... I'm not really an Amazon bash. I think it's incredible opportunities for many of us all over the world. But if you lose your account, if you lose your ASIN, you can actually take Amazon to arbitration, take the decision entirely out of their hands, and get the arbitrator to say, you know what, Mr. Bezos, turn the ASIN back on. Release the money, reinstate the account, okay? Even though it's against the agreement, we've had arbitrators award lost profits, and there's no appeal to it, okay? So that's what I'm going to be talking to you about today, that if you read my book and you strike out, you can go to arbitration. Enough about you, a little bit about me. I founded it. We are, not to pat myself on the back because I work with great people, we're the #1 suspension company, even though we're a law firm, in the world. We are the only suspension company where there's actually a team that works all in the same place, all college educated, all Americans writing to an American company your plans of action, okay? Nobody else has that. Nobody else has conference rooms where the people who are writing plans of action compare notes on every single plan of action. My practice has grown into about 35% just run-of-the-mill suspensions. You sold as new, this inauthentic nonsense where you got to give your invoices, packaging issues, high ODR rates. About 35% are intellectual property suspensions, okay? Love or hate lawyers. We tend to play both sides of the fence depending on who hires us. And now Amazon has been shifting now for a couple of years into a very brand-centric place. We also represent brands. We help you do your trademarks. We help protect your brand. We help build intellectual property rights into your products so that if someone starts hijacking your listing, you can do something about it. And arbitrations, we do, because unfortunately sellers get suspended. Unfortunately, they can't get themselves back. And about 20% of our practice, I speak with the lawyers for Amazon. I wouldn't say every day, but certainly every other day. And we represent about 75% of the arbitrations against Amazon that exist, okay? And the brand protection is growing. As you go into private label, protect your mark, protect your images, protect your verbiage, okay? Make sure you build an IP right into your products now. We can help you do that. I've also had the pleasure of working with other co-authors and writing several books. And I speak at events and I travel and I learn. Like, you might see me, I sit in the back, but I learn from the other speakers every day to try and learn some of what you guys face and how you can get better so that we can do better. And falling into this niche is just great, because I love working with entrepreneurs. Okay, now, let's get to you and your needs and what you need to know so you can sleep at night and not worry so much about that suspension email. This is how you most sellers will end up in an arbitration. You'll get that god-awful email, okay? You will put together a plan of action, okay? Now, there are really two ways to do a plan of action. You can do it yourself, or you can hire someone who's really going to write it for you. If you go online and you buy the forms, okay, like Zach said, you're like shooting yourself in the face. Forget the foot, okay? Don't buy the forms. If you're not going to hire someone who's really going to write it for you, you don't know who's writing it for you, do it yourself. It may not be as concise as it would be if you hire like a team to do it, but at least it'll be accurate and true, and it won't be cookie cutter, okay? But if you do, so you file your plan of action, you send it to seller support, product quality, whatever, okay? They say no, you try a few more times, they say, we're not reading your stuff anymore. So then you go to the next level, you go to the policy teams, and they ask more information, or you give it, you don't give it, and eventually they say no. And then you go to like the pinnacle of the amicable reinstatements, the Jeff Bezos escalation team. And you write to them, and they're supposed to do a top to bottom to top review of your account, and then make a decision. When they say no, it's difficult. You can still get back on amicably sometimes, but it really is difficult. If they say no, and you have $90,000 of your money they're withholding because someone has accused you of selling an authentic item, or they're holding your inventory, or you just need this account back, immediately file for arbitration, okay? You can do it yourself. It's not rocket science. It's not, these formulas that you guys are learning. You can do it yourself, but you want to get the ball rolling, because from the day you file to get your arbitration, you're looking at, it used to be about 3 months. Amazon's lawyers have been getting a little bit more and more and more savvy as we file more and more of these things. But you want to get it filed to start the deadlines rolling, okay? So this is how you end up going to an arbitration. Okay, this is you guys, okay? But as we know from the story, right, the rock took out the Goliath, okay? So these are like the outline of what I'm going to talk to you about how you go to arbitration, how you ended up there, okay? So that you know that you can still recoup your money, your inventory. We know they lose inventory all the time, okay? They'll log in 90 units when you sent in 100, or they'll log in 90,000 when you sent in 100,000. They refuse to release your money. One of our clients called, FBA, they called it TBA, theft by Amazon. Okay, now, anyone here know what the business services agreement is? All right, terms of service? Everyone knows terms of service. Participation agreement? Oh yeah, I know that. Those agreements don't mean anything. They do not govern your relationship with Amazon, okay? If you should click through to the definition section, you will end up at the BSA, the Business Services Agreement, and that's actually your contract with Amazon. It's pretty similar, it's a little more inclusive. That agreement, as well as the other ones, say you go to arbitration. In fact, Amazon wrote it so strongly that we have a case they're trying to get out of it, and they took us all the way to Seattle, right? So I file everything in New York, where I know the judges. And they said, well, we belong in court. And we took that unilateral agreement, and we gave it right back to them, okay? It's so inclusive. Any dispute you have with Amazon that you cannot resolve goes to arbitration. Any one. Okay? A little bit more about the business services agreement. It's hidden in the definition section, but unfortunately, it has been upheld by the Ninth Circuit, which is the federal court on the West Coast. Okay? Even though the agreement is so one-sided, it's illusory, they can kick you off at any time, blah, blah, blah. That agreement has been upheld. So, since the courts in Washington have upheld it, arbitration is much, much better, because arbitrators don't have to follow the agreement, they don't have to follow the law, and there's no appeal process. So it really is a really good thing for sellers that you go to arbitration, because if you were stuck going to court, we would always lose. In arbitration, you can often win, because the arbitrators can do what's fair. The arbitrators can do what's right. Okay, what does it cost? Okay, if you're filing for arbitration, their attorney's fees can be handled in two ways, okay? A flat fee, which most smaller sellers prefer. You want to know what it costs? or an hourly. I'd recommend for most businesses, large and small, you get a flat fee from a lawyer for any project, okay? Sometimes you will end up paying more if things resolve quickly. But if things resolve quickly, you're pretty happy anyway, right? If you get stuck and if everything goes wrong, at least you know what you're paying, okay? I'm not saying there's anything wrong with the hourly fee. We have many larger sellers who keep money in our account that we bill by the month. And a lot of times they save money. But unless you're like really big, where it's almost somebody else's money, get flat fees, whether it's for Amazon, buying a house, okay, any dispute, flat fees are better. You know what it's going to cost, okay? And it's never going to go up. Here are the fees for the arbitration. Now, regardless of your losses, unless there is a tremendous upside, okay, we suggest, if at all possible, only ask Amazon for the reinstatement of your ASIN, okay, or your account. Okay, you're always going to ask for that. It's equitable relief. You can always ask for that. And limit your damages to $75,000. Why? If you only ask for up to $75,000, your filing fees are less. Your arbitrator fee is also locked in under what the AAA has as their expedited procedure. Okay? You ask for $76,000, $80,000, $100,000, you're out of the expedited procedure. The discovery could go on. It could take an extra month of documents going back and forth. There are additional arguments that can be made on paper, and you open yourself up to the arbitrators asking you for more money, because they get then paid by the hour. And arbitrators can say, you know what, I don't really get this online shopping stuff. I'm going to need 10 more hours to figure this out. And you're paying half of that cost at $400, $500, $600 an hour. Okay? So unless there's a really, really big upside, you file for the expedited $75,000 cap. Okay? Now, just like lawsuits, arbitrations also settle. Okay? Amazon has been much more inclined to settle under the expedited procedure, even when they have to cut a check, than the full-blown arbitrations. I don't know why, but they're more likely to resolve it without going the distance, which means you get your account back, which means they release your money. You get your inventory back, put into your basket. If they have really just screwed you out of a tremendous amount of money, you're out $300,000, $400,000, $500,000, $600,000. I'll show you the sliding scale. But the AAA charges per dollar that you're asking for. It's 0 to 75, 75 to 150, and on it goes, higher and higher and higher. Okay, there are also a couple of risks for the sellers that are located outside the continental U.S. We learned really, really quickly to stress this is a U.S.-based seller. They are selling only in the U.S. Their products are in these FBA warehouses in the U.S. Because what we learned from one of our Chinese clients, that they were identified as an international dispute and got yanked right out of the expedited procedure. So I don't care where you live, okay? You focus in that demand for arbitration in the U.S. So you can check that box. This is U.S. We are, of course, we're not international. We only sell in the U.S. Okay. This is sort of a timeline. This is like the 12 steps to any arbitration. Okay? Amazon finally says no, or you've grown tired of banging your head against the wall. Okay? So you file a demand for arbitration, and you get to pick, venue is where it's going to be held. Venue is location. You get to pick your venue. Okay? We were always picking New York, so I always had a great chance of having some relationship or a common relationship with the arbitrators. Now we've sort of shifted where we'll pick where the seller is located, because Amazon started asking us to go to Seattle, and I don't want to go to Seattle. They're such a major employer. We don't want to be there. So you file your demand for arbitration. You file, you pay. If you're doing expedited, the cost is an initial fee of $850. That's it. That's what gets the game started. That's what gets you on the road to Amazon either settling with you, okay, or having an arbitrator make the decision. There are 17 days for Amazon to respond to it. Generally, they respond and say, it's one law firm, it's Davis Tremont. They say, we represent Amazon. We're not putting in an answer because everything's deemed denied. Okay? That's step number. That's 17 days. So it's relatively quick. You will then get a arbitration selection sheet, and I'll show you a copy of it. And they give you a list of either 5 or 10 different arbitrators. They give you the CV so you can look at it. I always look for someone with backgrounds either in like nuts and bolts type of law practice, okay, or trial lawyers, okay? Because we tend to see things in the same way of other people are experienced. So I'm a reformed trial lawyer, okay? I want a guy who's going to think out of the box. If I get a plaintiff's guy, I want that, or a small business guy. The last person I want is like a white shoe lawyer from an ivory tower who's going to follow contracts. Also, you'll see from time to time on the list, arbitrators who are not attorneys. They're business people. And those guys are also good because they recognize contracts where one side is getting screwed and they don't have to follow it. There is no appellate review. So you get that, you put your number in, both sides send in with their numbers. The first common number is your arbitrator. If that guy has a conflict, it's the next common number. Simple as that. Once you have an arbitrator selected, they'll schedule a preliminary conference. And all you're doing is scheduling. There's a checklist of things where you schedule when each thing's going to occur in your arbitration, including your hearing. Most of the arbitrators are really strict. They set a hearing, even though if Amazon asks for it, they claim all the time that they can't find the data, okay? Big, giant company, and they say, oh, no, she's out sick this week, okay? The arbitrators are great. You in a court of law, you get adjournment after adjournment. In an arbitration, you don't. It's a huge benefit. You can also ask Amazon for documents. Usually during that preliminary conference, Amazon will reveal why they won't reinstate you, right? Like you get suspended for an IP complaint, right? Only Logitech withdrew the complaint. So you file for arbitration. I should be reinstated. That complaint was bogus. They withdrew it, right? During that preliminary conference, the arbitrator is going to say, why won't you reinstate our account? And they'll put them right on the spot. And they'll say, well, she had this problem and that problem. They'll go through things you didn't even know about. And all you do is you make a list. You say, I want all the information, all the emails regarding that list of things you claim gave you a basis. Okay? And that's your demand for discovery. They're going to ask for general information about the account. They're going to ask how much money you lost, how much money you were making, where you sourced your goods. But you've already provided this anyway. In litigation, responding to demands used to be a real pain in the neck. Now it's easy. All you're sending in is your plan of action and your invoices, or your plan of action and your IP withdrawals. So it's really easy from our side of the fence to keep pushing the can towards your final hearing. Some arbitrators will either ask for a pre-hearing brief, or Amazon, to make it a bit more onerous, will say, we'd like to do pretrial briefs. Okay? All you really need to do, and it's better to simplify it and sort of dumb it down for the arbitrator who's less techy, than we are, okay, is your plan of action, because you've already set that forth. The preparation for your hearing, okay, is just figuring out how you're going to express to the arbitrator what you did, how you fixed it, how the suspension was unwarranted, and how this has devastated your account. And they're going to say, well, why don't you sell elsewhere? You say, well, in the U.S., it's 50 cents out of every dollar. It's 1 out of every 3 cents. There is no place else to go, okay? And the arbitrators believe it, okay? They know it. If you are selling in like the U.K., Amazon only is about 50% of the market. In the U.S., it's at like 80 and growing, okay? Then you have the actual hearing. Many people are intimidated by court, okay? I've probably tried 1,000 cases before I sort of shifted away from that and started helping all of you, okay? I never met a witness who was psyched for court, okay? At the hearing, they're usually telephonic. It could be video on Skype, where you could be in your own comfortable environment, or it's in a conference room, okay? And there's no judge. There's nobody sitting there up on an elevated platform in a robe, okay, intimidating you, okay? The arbitrators are doing, this is easy work for lawyers to do part-time. And they'll just say, all right, why are you here? Tell me what happened, okay? Or if you have a lawyer, the lawyer's job is to really just ask you questions that just sort of poke you to tell your story, okay? And that's it. There's no like standing up, I object. Doesn't exist, okay? This is a huge benefit to sellers, that you don't have to go to court. And at Amazon kind of took it away from themselves. Like, I'm always surprised they haven't changed gears, Because if you had to go to court, you might say, I can't, I'm not going to do that. Court's 2-3 years sometimes. There are appeals if you win. This is it. Arbitration is a piece of cake, okay? An absolutely boon to you in your agreement. Once you have the hearing, sometimes they'll ask you to outline, the military method. Tell them what you're going to say it, tell them what you said. Some arbitrators are the same way, so they can make the decision. 2 weeks later, you get a decision, okay? And the best part of that decision is Amazon simply complies, okay? Their arbitration agreement is more important than any single arbitration, okay? So it applies to millions and millions and millions of sellers, okay? What they do is kind of odd is that when they have to cut a check, they'll actually funnel the check through their lawyers, which is a bit unusual, but they pay and they comply, okay? Also, many sellers have asked me, if I take them to arbitration about my ASIN, are they going to shut down my account, okay? Is there going to be any retaliation? And I've told this to sellers, I wouldn't say hundreds, but certainly dozens of times, okay, that I have never seen any evidence of Amazon retaliating for exercising your rights to go to arbitration. Not once. I mean, it doesn't necessarily mean one of you won't be the first, because your agreement is an at-will agreement, okay? But we haven't seen it. And back in that awful book, the Amazon Law Library, which is like 500 pages of cases, okay, where we analyze cases, we never saw any retaliation. You are safe to take Amazon to arbitration, okay? At least so far. Okay, I know you can't read it, but this is a demand for arbitration, okay? We literally do it in the form of a business letter. Dear AAA, under this agreement, we're taking Amazon to arbitration because they suspended us and refused to reinstate, even though Logitech withdrew their baseless IP complaint. Even though we showed we were selling genuine Logitech clickers, okay? And they're holding $50,000 of my money. Amazon says, well, the agreement says we can hold it. It doesn't say they can seize it, okay? It doesn't say we can steal from you, okay? So you can literally just write in letter form what your claims are, and you can take a lot of that from your plans of action and send that in and get the ball going. Okay, I don't have my glasses. Can you guys read the fees? Yes? Okay, I guess my eyes are getting worse and worse. That's why Cherish called me a father, for God's sake. So anyway, up to $75,000 with all the equitable relief you want, okay? You look at minimal fees, okay? You go a little bit higher, it's a little bit more. As you get higher and higher, it's not that the AAA's fees are so tremendous, it's that the arbitrator is just going to kill you, okay? But sometimes you look at it. What I like to do in any case, whether it's arbitration or litigation, I want to see the possibility of recouping 5 to 10 times your litigation costs, okay? If it's going to cost you 10, I want the possibility of winning at least 50 grand, okay? Hopefully closer to 100, or else just not worth it as a business decision in my mind, because nothing's guaranteed, okay? We've been very successful at arbitration, both in settlement and in getting decisions. But if you're not making at least 5 times the investment, you may want to think about it again, okay? So these are the filing fees. Okay, the arbitrator selection form I told you about, that's it, okay? You literally get it, you read the CVs, you decide who you think your number 1, 2, 3, 4. I usually divide them in people that I absolutely despise and everybody else, okay? Once in a while, you'll see that some common connection, right? You'll see, oh my God, the arbitrator coaches T-ball too, right? Like, I'm picking that guy first. And somehow you make a note, you work in T-ball into your presentation. Or in some, so listen, could we reschedule for the 3rd instead of the 4th? I got the Long Beach Rockies game that day. I'm a T-ball coach, okay? And these things work. It's all persuasion. Everything is persuasion, okay? And that's it. You get it, you number it, you send it back in. Then you get a letter like this, right? And it says, you've been appointed such and such an arbitrator. All right? Michael Einbender actually is a T-ball coach. Much like me. It's kind of cool. Okay, When you have your preliminary conference, some arbitrators kind of do it kind of freestyle. Most just follow the AAA form, which you could see in advance. Okay? They start working backwards, the hearing date. Okay? Amazon used to not fight hearing dates. I always look for 2 months down the road. Okay? You'd end up at 3. Now they're pushing back and back and back. So you really kind of have to stand up and say, no, I'm out of business. Okay? My clients, not only are they out of business, their money's being withheld and their inventory's been withheld. You know that picture with the guy locked out sitting there? That's you, right? You get suspended, right? Your inventory, your money, right? The money you already owned. It's like the landlord coming. One landlord owns every single storefront on the planet, okay? So you tell the arbitrator, say, I have no place else to go. I need this done in 3 months, okay? And they will. Sometimes you can push it a little bit faster, okay? But you just work backwards and you feel like, okay, if our hearing date is December 1, then we need the final documents, 11/15, the demand 2 weeks before that. You work your way back to the time you're on the phone sitting on that conference. And all the conferences, unlike court, right, are on the telephone. That's it. Do it wherever you want. When I used to try cases, what drove clients crazy, I was always the good guy, okay? I was always the plaintiff going after the big guys, okay? And it drove the little guys crazy that, AIG, right, would come in and say, we need 3 months. We need a 3-month adjournment, right? I live on the East Coast. Hurricane Sandy came in. I mean, my whole town was under like 4 feet of water. I had to gut my house and my ex-wife's house, right? But, right, I showed up in court where the lawyers who came in for AIG, right, and I'm in jeans. I got like sheetrock embedded in my jeans. They're like, our phones are down right now. We need 2 months, right? I'm like, are you kidding me? I don't have a toilet. I'm here. Amazon's starting to do that a bit, but the arbitrators don't stand for it, okay? Also, arbitrators, unlike judges, they do better by sort of splitting the baby, right? Because if Mr. Einbender, right, was slaughtering my sellers, I'm not going to pick him again, right? If he's slaughtering Amazon in every case, Amazon's not going to pick him again. So a lot of times, it's not really win or lose. There's a lot of splitting the baby in arbitration, okay? But one of the things we'll split up the claims. Like we recently had one case where Amazon screwed him out of a certain amount of money, right, until the suspension notice came, and then continued to screw him out of money because he was still feeding traffic to Amazon, and like an associate's, right? So we split it up. I said, of course they shouldn't get all this business for nothing. They should pay. They should also pay afterwards because they were still making money. They could have turned off the spigot, right? So we anticipate the arbitrator is not going to give us everything, but you give them a way of dividing it so the arbitrators can kind of keep everybody relatively happy, and they keep getting picked. Right, this is the schedule. This is what the schedule looks like. Okay, what actually happens at the hearing? Okay? Now, some arbitrators are a little crustier than others. Others are a little more, free and touchy-feely. But this is the general structure, okay? You sit down at a conference table, okay? Or you're on the phone, which is more likely. And he says, okay, claimant, you filed this. Would you like to say anything? And you say, yeah. So what do you want to say? I said, all I did is bust my tail every day, 7 days a week, watching my metrics, selling genuine products, doing everything right, okay? And they suspended me. So I jumped through every hoop they put in front of me, okay? And they still won't reinstate me. And they're holding all my inventory, and they're holding all my money, and they don't have any right to steal from me. I want my account back. I want my money. Done. That's your opening statement, okay? And Amazon gets up there as corporate lawyers do, and they argue about the contract and the this and this clause and that clause and Exhibit 64. And it's like they're talking to a wall because the arbitrators are trying to do what's fair. Again, there's no appellate review. They don't answer to anybody, okay? Then the seller, as the claimant, you will get to tell your story first, okay? Direct testimony, just like in court. You just tell what happened. If you hire a lawyer, he'll ask you questions to draw the story out in an organized, more persuasive manner, but you just tell what happened, right? The next would be the cross-examination. Amazon's lawyer is going to ask you questions, okay? And you need to answer them, okay? You should be honest, okay? But your answer is your answer. It's not like they're going to pull documents out that you haven't seen before and surprise you, okay? And that's it. You just answer the questions. Then Amazon will bring their witnesses. They started bringing one, now they're usually bringing two. They're usually bringing like an Amazon investigation guy, right? And they're bringing more of a fact witness, okay, about the contract and about this, that, or how the Amazon accounts work. Then the investigation guy testifies how you violated it, okay? What they don't bring, which is incredibly persuasive, are any of the actual people who read your emails. Why? Because they're in freaking India, okay? And Amazon's not going to fly them in, and they have a relatively high turnover, okay? And so they didn't bring them in. So my cross-examination is almost rote. I'm like, were you involved in this particular suspension? No. Who was? Well, let me look through. Oh, Liz O. Is Liz O in Hyderabad or Bangalore? Oh, well, I don't know. Well, she's not here, right? No. And she would have the best knowledge of what actually occurred? Well, yes. Great. Move to strike the testimony. Or how about this? Have you guys experienced that the feeling that Amazon suspends you, but they won't tell you why? Right? Yes? Thank you. Well, their security guys sometimes will come and testify on related accounts. You know, related accounts where you're not allowed to have more than one account. Amazon says, you, sir, have to put all your eggs in one basket, while we're the most diversified company that ever existed. Right? But screw you. So you say, screw it, that's crazy. I'm going to open up multiple accounts, which I'm a huge proponent of if you can do it really well. Okay? I don't have my glasses. I can't see that. I think my time is limited. I don't know by how much, though. So anyway, we had a related accounts case. Security guy comes back. He testifies. I said, that's great. I said, could you tell me all the different ways Amazon can link related accounts? He says, I can't tell you that. I said, well, Amazon identified you as the witness. Yeah. And you're testifying that you caught my client with related accounts. Oh, yeah. How? I can't tell you that. Why? It's a secret. I said, that's great. I said, Mr. Arbitrator, I want to strike all of his testimony. It made a really easy case to win. Okay? So if you have an issue like that where Amazon won't tell you why, those are like, it's like low-hanging fruit. Okay? Put them on the spot. Either they're going to tell you and you're going to tell all of us, right? Or you're going to get your account back because their witness, their testimony will be ignored since they don't allow you to cross-examine them. Okay? Those are Amazon witnesses. And at the end, you get to tell the arbitrator again how you've shown your account should be reinstated. Okay? If you have some sort of hook in your business, you use it. This is all plans of action all the way through arbitrations are nothing more than exercises in persuasive writing or persuasion. Okay? If you had to lay off a single mom with a disabled kid, bring it up. If you employed vets and now they lost their job, bring it up. Bring up the real-world ramifications of Amazon's ludicrous treatment of third-party sellers. Because it's all about persuading that arbitrator. Okay? And most people have had to change jobs. Most people have had hard times. Okay? Most people have not experienced a landlord who locks them out and keeps all their money and there's no place else to rent. Right? But most of them there are some universal things. Okay? And you need to use those in an arbitration. It's all about persuasion. Same thing you do it in a plan. You just got to persuade the guy in Bangalore or Hyderabad to click reinstatement rather than ask you for more information. That's what a closing argument is all about. So you can get reinstated, okay? You can. You could take the decision out of Amazon's hands, take them to arbitration. It takes a little more time. It costs a few more bucks, but you're not dead in the water. That's it. That's my presentation. Hope I taught you something.
Thank you so much, CJ. Any questions for CJ?
When a professor's asking you questions, I'm immediately getting tense.
I don't know if I'm the professor. Okay. All right. I'm Professor O'Connor from, I don't know, some university. University of Malaysia now. All right. So this is exciting. And when you're talking, I'm thinking, okay, so what is the situation? Are there any numbers of how many cases there are? Like, is this all secret? that generally, and then since April, how many cases have you been involved with?
We're involved in around 10 to 15 open arbitrations at any given point in time. Some are resolving and settling, some are going to hearing. Usually about 10 or 15. Amazon's lawyers, it's not the in-house guys. They farm it out to Davis Tremont, which is a great firm with a lot of great lawyers, and we have a great working relationship. They told me I have 75%. So if you do the reverse numbers, let's say there's an open 15 or 20 cases at any given point in time, then I guess there's probably roughly 30 all in with Amazon. But it is growing, because as they shut people down, they can't get back on, they'll learn about arbitrations and filing. So the answer is I don't know, but if I work my way backwards, I'd probably say there's somewhere around 35 open arbitrations at any given point in time. That's it. Which is why they'll produce witnesses who will refuse to answer, because who gives a hoot about 35 sellers when they're protecting that ridiculous agreement on millions and millions of sellers. So this is really, it's a good thing. It should help you sleep at night. That was a long-winded answer, I'm sorry.
I'm Brian, I'm from the US. I've had my account suspended once, right before Christmas. It was a nightmare. We went through the same process of sending in our plan, rejected, Bezos escalation, the exact timeline you told me. And we kept getting automated responses like they didn't even read it continually. And I just wanted to ask, because you went into more like the arbitration side, which is, of course, good for your business if you go to arbitration, but do you have any recommendations once that happens, what to do in order to avoid arbitration? Because I went to hell with getting suspended, but in my mind, I'd be even going deeper into hell if I had to go into arbitration.
All right, let me go back a bit. Okay? Look, 10%, 20% at most, okay? My whole business model, this is really a second career for me, okay? I was a plaintiff's trial lawyer for many, many years. I loved it. I don't miss it a bit, but I loved it, okay? So I'm able to build this practice exactly how I think it should be done, which means resolutions, okay? None of you ever want to be in court over anything. It's bad, it's costly, it's time-consuming, it's draining. So it's all about resolutions. What I would do, right, is take another look at everything you submitted. Look at it with fresh eyes and write to them again and see what happens. All they can do is worst is they're silent, right, or they say no. That's it. I would try that again and go through the same 3 levels. Seller performance, product quality, right? Policy team, Bezos, okay? We've had some cases where it was like a 4-year-old account. And we just looked at it again and redid it, okay? Things have changed, 4 years ago, 5 years ago, all these things were read in Seattle, right? Now they're read in Hyderabad and Bangalore. We try a lot to find people who used to work for Amazon and then interview them. They get about 3.5 minutes per plan of action. A lot of other people who do like the speaking in the United States think they're being read by bots. I don't believe that. We don't really know for sure. Nobody does. They're constantly changing and they do everything erratically. I think there are people looking at it, but if you're like at the 4 p.m. one on an 8-hour shift and they already fell behind, we know they answer by picking blurbs. And it's much easier to pick a blurb that says, give me more information, move on to the next one. They got to catch up. So if I were you and in that position, I would start again. Okay? Could you just end up wasting time banging your head against the wall? Yes. But it's still worth a shot, because getting reinstated amicably is much, much faster, it's much more efficient, and you get your money rather than going through arbitration. Arbitration is if you can't get reinstated. That's it.
Great, thanks.
Thanks, CJ, for the great presentation. My name is Gary. I live in Shanghai. I'm an Amazon seller. I see that you probably have a ton of experience dealing with sellers that have been suspended. I'm just curious, what are the top 3 reasons that Amazon would suspend a seller, and what would be like the success rate that these sellers can get reinstated in your experience?
Inauthentic, you sold as new, and baseless, you thought BS was something else, baseless IP complaints, okay? Lawyers in New York are not allowed to market by success rates. And in reality, success rates are bullshit anyway. Because I know we only take cases that we think we're going to win, okay? We don't bat 1,000, okay? You cannot work in the Amazon space and not lose once in a while, whether it's picking a product or helping with suspensions. I do see, I only see the problems. You know, rarely does someone call me up unless we already have a relationship and say, hey, just wanted to touch base. Things are going great. You know, then they don't call me. And this is practically all that we do. I'm a small town guy, so I still find myself getting enmeshed in, you know, my neighbor's drama from time to time. But the rest of the practice, my partner Anthony and the whole team of paralegals and the staff, this is all they do, day in and day out. To answer your question, inauthentic, you sold as new, and then IP complaints. Inauthentic is just invoices. It's not your stuff's fake. It's just give us the invoices. Okay? You sold as new doesn't really mean that somebody wore the shoes and then sent them back. It means it just didn't arrive in the pristine packaging, or the packaging was a bit dated. You know, cosmetics, the packaging changes every other minute, right? And they'll get it. It doesn't look the same as they would see in the store. They'd say, "Oh, it's you sold as new." It's not. But those are the top three. So to prepare for those as a seller, keep your records, keep your invoices. Okay? Keep a date on your packaging. Make sure that when the customer gets it, it's exactly what they should expect. And you're still going to get complaints because people like to scam free stuff. But those are the top three.
CJ. KJ here, over here. So thank you, by the way, for taking the time.
I left my glasses in my other suit, I guess.
Yeah. Thanks for taking the time to learn more about this industry to help us. Seriously, I appreciate that there's someone who's really dug in to figure this out. But my question is around damages. So like in his example, he lost his account right before Christmas. So do damages ever factor into the equation? Like I lost this much in sales because of the suspension during an arbitration procedure?
Yes and no, right? Sorry to be a lawyer, okay? Yes, we ask for them, and occasionally we do get them, okay? However, your agreement with them says you cannot recoup lost profits. But again, the arbitrators, if they go outside the agreement, there's no remedy, right? So we have received it. And I'm not going to argue again. But we ask. I know, and I joke with John Goldmark. He's the partner over at Davis Tremont. He's like, you know, that's outside the agreement. Like, what are you talking about? So you do ask every time you ask for it. I still suggest you stay under the $75,000 cap to all the other benefits. And since it is against the agreement, it's a little bit harder to get, or a lot harder to get, but you can get it. Also, you guys are going to start seeing the suspensions generally ramp up this time of year. And it gets more and more and more. But the reinstatements come a lot faster also. Okay? So if you get it, don't sweat. Put together your plan of action. Okay? Look, everyone got a copy of the book. It sets the 3 categories of what to do. You have sample language. Okay? If you're uncomfortable, hire us to do it for you. Okay? But just get it out. Quality, because the first swing at the bat is important. Okay? But the reinstatements come a lot faster this time of year as well.
We'll take one last question.
Yeah, hi.
Thank you
CJ.
for standing.
Yeah. Thanks for a great presentation. Very interesting. My name is Alphonse. I'm based in Hong Kong. And U.S. may not be my main target market. So all what I see is arbitration on U.S. soil. Now, would there arbitration in other places possible, or would it not make sense?
It's not in the agreement. Like if you're focusing on Europe, then if you have a dispute that you can't resolve, you have to go to court in Luxembourg.
Okay.
Which is really expensive.
I believe so. Thank you. Yeah.
Okay, thank you so much, CJ. That was amazing.